Perfect. Everything is ready. We have 399 participants, which makes me enormously happy. And with a bit of a delay, we can officially start. So, good afternoon, everyone. Hello, Chris. Hello, Professor Lilic. And hello to all the students who came today to listen to one a bit peculiar workshop titled Legal Education in the UK Between Memes and Reality. And our today's speaker is Professor Christopher Taggart, Senior Lecturer at the University of Surrey. And the workshop is first of its kind, and it is organized within the Horizon Twining Project Advancing Cooperation on the Foundations of Law, or in short, ALF project. And I will just use a minute to quickly introduce the ALF project. The main objective of the ALF project is to promote University of Belgrade Faculty of Law in becoming a widely known and sought after top-class European research and teaching institution. Objective will be achieved through 3-year-long transfer of foundational knowledge from 3 leading research institutions at the European level. One is University of Lisbon, second is University of Genova, and the third one is University of Surrey. And as I said, Professor Taggart is from University of Surrey. And now to go back to the workshop. The topic is Between Memes and Reality, Legal Education in UK, and we will start, of course, as any lawyer, by a definition. So what is a meme? According to Oxford Dictionary, the definition of the meme is an image, video, piece of text, etc., typically humorous in nature, that is copied and spread rapidly by internet users, often with slight variations. And it is exactly what we'll be doing today. We will be commenting on the memes, which has the topic legal education. And we are more than eager to hear whether the memes really reflect reality in UK and to learn something more about legal education and legal profession in UK. So without any further ado, I will now share my PowerPoint presentation on which you will be able to see the memes, and then I invite you, Chris, to introduce himself and to start this workshop. Chris, the floor is yours.
Well, thank you very much. Thank you, everyone, for being a part of this. I'm really pleased to share a little bit from my personal background about, as you might tell immediately by my accent that I'm not originally from the UK. I'll reveal the truth, right? I am originally from the United States. More specifically from New Jersey, but Mila had suggested, and I think it's a good idea, just to give everyone listening a quick overview of some of the highlights of my background, so that you have a sense of where I'm coming from. Because although for the last 8 years, I've been a lecturer and then senior lecturer at the University of Surrey School of Law, so I know quite a bit about just the nature of legal education directly, and also indirectly about some of the professional aspects in the UK, although I think many of those are similar to my personal experience as a lawyer, even when I was in the United States. So I'm going to be drawing on that a little bit. So just to give a quick background, basically after when I was at uni, I studied mathematics and philosophy. And then immediately after my undergraduate degree, did a master's and PhD actually in analytic philosophy. This was before I became a lawyer or interested in law. And essentially what happened was I wound up getting this job where I actually had to develop some expertise in environmental law, regulatory compliance. So I was running around telling people in industry how to manage hazardous waste and things like that without getting into trouble. And that got me very interested into law. and then combining the philosophy sort of with the law. So I then went to Yale Law School. I got a JD in the United States. The study of law is a graduate study, right? So I did that. And then after that, I was practicing in a large firm in New York City. And so I'll say a little bit about what that was like, because my understanding is that's quite similar to one option in the UK, which is practicing at a large solicitor's firm. So I'm going to be drawing upon that a little bit to say something about that. After that, I came to realize that my true heart, my true goal was to be an educator and to teach as opposed to practicing law. So I then went to Harvard Law School. I did an LLM and then remained at Harvard Law School and did a second academic doctorate about law and economics, but I used a lot of sort of the philosophical stuff in there. And then after that, eventually, I kind of put it all together, and then I wound up unexpectedly, quite originally, in England at the University of Surrey. So that's giving you a quick idea of where I'm coming from. So what I'm going to do is go through these memes, say a little bit, as it occurs to me about each one. Some of them I might say more about than others. But my goal is to leave us a little bit of time at the end so that, anybody who wants to have any general questions, we can have a discussion about anything anyone is particularly interested in. So Mila, would you go ahead and advance the next slide here? So we'll see what our first meme is. Ah, yes. Some insights about the University of Surrey. Well, the University of Surrey is, it was founded in 1966. It actually teaches a number of different subjects. It has a number of different faculties. So the School of Law is located underneath one of the main faculties, which is the Faculty of Arts and Social Sciences, which actually combines an enormously large number of very disparate things. And in fact, one thing that's kind of happening right now is we're combining underneath a kind of super school, you might say, call it a super school, the School of Law, the Social Sciences Department, the Political Sciences Department, and the Economics Department into kind of a super school, but each one will also still maintains, of course, its individuality. So that's kind of where the School of Law, I would say, fits within the big picture. Surrey overall is known actually for being like an engineering school as well. I mean, it does just about everything. We're about I guess you would call us a fairly beefy kind of mid-sized maybe university, not gigantic like some of them in the United States, but fairly sizable. And also drawing from a lot of students, not only from across the UK, but also from many different countries. So that's kind of a general sense, I would say, of the university. Next slide. Yes, now this meme I did want to say a little bit more detail about. I think I really liked this this peculiar dog here because it gave me some ideas about one thing that I think can make studying law hard in the UK, and indeed actually even in the United States, but for the same kind of reason. So let me kind of pull it together here. Throughout the world, there are different, as many of you may know or probably know, there are different legal systems under the secular division, right? You have your civil legal systems and you have your common law legal systems. Now, the UK is basically like it's in effect the queen mother of all common law legal systems, right? That then evolved throughout the world. And one of the reasons I think I like this picture in terms of studying law in the UK, and just like any common law jurisdiction, a lot of a lot of what one learns is how to think like a common law lawyer. And this is very, very tightly connected to the history of the common law and how the legal systems, right, in such jurisdictions originated in effect by sort of judges running around solving all these individual disputes, and then over time, writing official opinions that officially sort of explained why the results were the way they were, and then from all these opinions over time, developed a number of legal principles, right? So the idea is that in the beginning, sort of, right, the law is just all this judge-made law, basically. And then later on, what happens then is super added on top of that, right, is your legislature, parliament, right, or, say in the United States on the federal level, it would be Congress, and, and so on and so forth. And, the idea is that statutory law kind of outranks common law principles, but it only outranks it if it, kind of jumps in there and sort of imposes itself and says, okay, we're now going to change the law of certain kinds of contracts of sales of goods or something like that. But unless there's a statute that kind of jumps in there and does that, it's that underlying common law throughout England, for example, that is, that the contract principles evolve from the doctrine of consideration and so forth. So that's one kind of interesting thing. And because of that, in England, a lot of studying law is learning how not just to articulate rules, but to apply rules in practice to a very particular set of facts. And all about analogizing and disanalogizing from previous cases, right? It's not like a systematic civil code, like sort of, which is more like a civil code is more of like a logically constructed, it's kind of funny, even though I'm a common law lawyer, I kind of feel like I'm kind of a common law lawyer, a civil lawyer trapped in a common law lawyer's body in a way or something like that. Because I kind of there's part of me that is very attracted to this idea of this organized code that's sort of designed, right, from its inception to deal with all these different problems, right? But that's just not the way it happened in England. And so, we really emphasize the importance of the facts and learning how to do that. Now, what can happen, though, when you do that is then you can get some very interesting situations. So, for example, H.L.A. Hart, who was a famous English legal philosopher, had this very famous case that I often like to use when I teach law here in the UK to get students thinking about this. And the case is sometimes called the no vehicles in the park case. Okay? And that's what the dog really reminded me of. So I wanted to share that with you. It's about the difficulties, right, in studying law and getting used to thinking like this, right? So I say to the students, okay, so imagine that you're this judge and, you're there and you're the judge of this village, and the village has this park in it, right, that people like to go to the park and so forth. And for a long time, there's been this well-publicized, codified rule, right, that governs the park. And it just says that no one shall operate a vehicle within the park, and if anybody does, then they are to be punished basically by being given a certain fine. And then I would then say to the students, okay, well, what happens now if, say, one day, consider the following people, right? And then I'll say something like, all right, well, let's say there's a man, let's say he's a proud father and he's pushing his baby along in a baby carriage, enjoying the park and talking to his friends and everything. But it's a really fancy baby carriage that has this little button on it, but you have to hold the button down. If you hold the button down, right, like this little teeny motor kind of like gives it like a little boost to sit, like makes it a little easier to push it uphill, and he uses it a couple times. Then suddenly, a police officer comes out and gives him a ticket, right? He says, you can't do that. You just operated a vehicle in the park, right? Or these other people get like, they have a license, they get a license or a permit to set up a war, an educational war memorial where they have this Jeep that was used, during the war, but they completely disconnect the engine from the tires, and they kind of push it on there, right? And they've got it there, and then during one of the demonstrations, they turn on the engine to show how the Jeep's headlights worked or something like that, during the battle of whatever it was, and then, as you might guess, bam, out comes the police officer, right? So, now imagine that these people show up in your courtroom the next day. And basically, let's take the baby carriage guy, right? So he comes in there and, he and the police officer are in complete agreement about every single fact. I mean, there's no dispute on the evidence as to what all the facts are. It's just that the man just says, look, on this set of facts, it's just not true that I violated that rule. And the police officer says, yes, it is. You definitely, right? So if you think about it, right, because the law of any jurisdiction that uses a natural language, whatever the language is, whether it's English or some other language, doesn't matter, right? There are going to be certain terms like vehicle, right? Or say sitting, to use the dog example, right? And the thing is, it's just a fact about any natural language at all that there are what they call penumbral cases. It's not clear, right? What, in this, I mean, is that dog sitting, standing, or laying down? And there's a case, if there's some kind of a rule, right, that actually has those words in it. One of the things that's funny about common law is you could run across what's called a gap in the law. And where a gap in the law is just basically some kind of a legal proposition that, has to be decided, in order to decide a case. Is this guy going to get the ticket or not? But there just doesn't seem to be a fact of the matter, at least not a clear fact of the matter about, whether this guy was, operating a vehicle, and he was clearly operating the baby carriage, right? Or think about the Jeep guy, right? Well, clearly the Jeep is a vehicle, but was he really operating the vehicle by turning the lights on? I mean, kind of, but, he wasn't operating it, like as a vehicle to move around, right? So one of the things I always like to tell students is that I think that one of the things that makes studying law hard in the UK is not only that you have to get used to solving particular fact patterns or problems in a fact-sensitive way in terms of the rules, but in really a lot of the cases that are studied in the UK, which are often appellate cases, right? In an appellate case, that's where, somebody's saying, it's not like a normal trial case, right? This is an appellate case because somebody's arguing, right, that down below there was some kind of legal error, right, that was made, and the judge misapplied the rule or something like that, right? And so, now there are going to be arguments on both sides, right, as to what the law even really means, right? And this is the thing that you have to learn, right, in order to become better and better and better at legal thinking. So it's almost like studying law in the UK is more like acquiring an ability in a way, than by just learning a bunch of, you have to learn a bunch of important legal facts, yes. And you have to learn the rules, yes. But the real underlying thing about the whole thing is really acquiring a sensitivity to this ability, and even noticing that in cases like, is that particular dog in that particular case sitting? Is he standing? And if there's a rule that says something like, anybody who has a dog that's sitting on those bleachers, right, has violated, like somehow, for some reason, whatever the town is thinks, boy, it should be illegal for anyone to let their dog sit on those bleachers, right? There could be a legal issue here, right? And if you think about it, right, in a way, and I think this is maybe a little more true in the US than the UK, but still, to some extent, I think it's there in the UK, is you've got to think about the purposes, policies, and principles that underlie why they wrote that rule. And in a way, the judge, whether the judge likes it or not, at least implicitly, they won't like say it in the opinion, but it's almost like implicitly they kind of have to think a little bit like a lawmaker. Because if there's a gap in the law, then in a sense they literally are making it, right? And so therefore, as a lawyer representing a client in a case like this, not only do you have to be, learn how to apply the law to the facts, but especially in a hard or interesting case, kind of think about, when the judge decides the case, how is that judge going to have to think a little bit like a lawmaker, actually, notwithstanding the tradition of the separation of powers, right? So I'm not suggesting that the laws are trying to make, excuse me, that the
sorry, can someone has to mute himself? Yeah. Thank you.
Yeah, I think so. Okay, great. Thank you. Okay, I think we're good. Thank you. So at any rate, so I would say this is a nice meme, I think, to give me a chance to kind of express some of the nature, I think, of what we're really after. Certainly when I teach law, is really trying to get at this in the UK. All right, can we have the next slide, please? Okay, how much practical knowledge? Well, yeah, good. So it depends, but they can get a lot. I mean, all law students at the Surrey of Law sort of must get a certain amount of practical knowledge, and a lot of the practical knowledge has to do with, things like, just how to go about basically carrying out legal research, how, if you want to pursue law professionally in the UK, you are expected to do things like cite your cases or cite your statutes. There's a lot of that kind of running through it. And I think for those students who really want to get, even more advanced in terms of the practical knowledge, we have the undergraduate students at our school, and I'm sure this is common. I know it's actually common in many UK schools. Well, the student unions will have things like a series of negotiation workshops and even competitions, or client interviewing, right? Or moot court and so forth. And at least at our school, a lot of us will, and even though I'm not primarily a legal practice guy, especially in England, I always like to be a part of that. So I enjoy helping out the main person who's got a lot of experience, like as a solicitor or something. And I always like to call myself, his name is Timothy. And so I always like to say, well, I'm Timothy's glamorous assistant, because I come in and what I'll do is I'll play the role of like the client or whatever it is. And so sometimes, I might try to give him a little bit of a challenge, pretend that I'm this difficult client or something like this. And then he'll model for students, how to do a client interview, things like that. In addition, we have a whole, and I think this is fairly common in many UK law schools, a whole bunch of clinics, right, that we run, and access to justice, helping out with landlord-tenant claims, things like this that actually get students involved in a very practical, hands-on way. Another thing that I'll come back to a little bit later is that the University of Surrey throughout, and the law school, specifically, has an option that many of our students take called the placement training year. And, I'm not saying that every school in the UK has this built into it, but I imagine many do. At Surrey, we do. And then the idea there is that, let's say you want to do your 3-year LLB, that's the traditional 3 years, but there's an option to do your first 2 years, right, at the university. And then if you want to, and we have this entire program that talks about making a resume, how to interview for jobs, and we have networks of connections where we try to help students get placed with all kinds of employers. And so they spend the 3rd year getting real life work experience, which many of the students then come back. And I'm involved in that, actually, not as one of the main people, but I like to be involved in it. So at the end, I'm one of the people that will evaluate their presentations, where they're sort of explaining everything that they did, and there's certain criteria they have to reflect on it. And it's interesting because the students then ask each other questions, and so what was this like, what was that like? And then when they come back then and do their final year in year 4, they're then bringing into that final year all that work experience. And then a lot of the students will report that even when in doing the non-practical stuff in their final year, the practical skills that they learned, the knowledge, that practical knowledge, that know-how, right? And it's not just practical knowledge in the sense of facts that are practically applicable. It's knowing how, right, to be professional, right? Knowing, learning how to communicate with a client, depending upon what kind of place you're working at, right? Learning how to, even in a very nitty-gritty, practical way, communicate to your coworkers, right? Or communicate to your superiors, and you build that competence, right? So I would say, ultimately, the answer is going to be, it depends. So all students are going to get, a good solid basis of practical knowledge. You have to, but some of them can get a lot of it, right? But that's up to the student. Okay, so how about the next need? See how subjects are divided in faculties. Yeah, so I would say in terms of specialization in certain areas of law, I can describe, it's definitely true that many different UK law faculties will handle this in different ways, and I can elaborate how we do it currently at Surrey. So when students, come to Surrey, I would say the central or the primary program that they would sign up for is your 3-year, LLB honors program, right? But we have a number of different options. So, for example, a student could do law and I believe it's international studies. Now, if they do that, then it's a 3-year program, but during each of the years, some of their classes will not be taught by an academic staff member of the law school, okay, but will instead be taught by an academic member of the political science department. who specializes in international relations and policies and things like that. Of course, then on the other side, right, when they are in the law school, predictably, they're going to emphasize certain modules like international law and, international environmental law and things like that we have. So that would be one possibility. Another possibility, and actually I am actually technically the head guy of this, the point person for it administratively, is law with criminology. And that one we do in combination with the sociology department, right? So there, if a student is interested in law and criminology, in addition to taking, their standard menu of law modules, and obviously that's what they want to do, a lot of criminal law in there, maybe sentencing, criminal law, but then also dealing with classes taught by empirical scientists who study things like the causes of criminal behavior, and other kinds of important sociological issues as well. So that's a possibility. Other possibilities, and I am the head of a number of these as well, sort of the administrator. But within the LLB, remember that's the first one I told you about. You can do the philosophy, politics, and law pathway within that. And if you do that, and you take certain kinds of courses, and as the name suggests, there's going to be a lot of philosophical thinking and policy thinking and kind of more sort of theoretical thinking, solving problems that involve hard problems like the dog problem, right? Is it sitting? Is it standing? That kind of thing. And the reason we have that is we found that a lot of employers in the UK are particularly interested in hiring people who have been trained sort of to, how should we say, think outside the box creatively, taking into account not only what the rules are, but really kind of going beyond that to the underlying political or philosophical principles, because sometimes you just have to be able to do that in order to really be good at solving certain kinds of problems. And so we've discovered that I think there's a call for this. And so that's one of the reasons we offered that. Another pathway we offer specialization is the law with technology pathway, which has a ton to do with the emergence of artificial intelligence and the internet, and just the really transformative features that are occurring here with the advent of the computer age, and just how law is practiced. It's just different, changing now. And in that connection, for example, we'll have courses on that. We have connections with actually some practitioners who actually kind of do this, right, to talk to students and really help them along those lines. So again, this is how Surrey does it, and I believe we're also coming up with a new law, environmental law specialty. I believe it's the first one in the UK for undergraduates. So, different UK universities will do this in different ways, but that's how we do it. And so I think, yeah, there's a lot of potential for students, depending on what their interests are, to study different specializations within law. Okay, next meme, please. Is it hard to enter? Well, yes. So basically, in the UK, I would say, a lot of the students certainly are going to be domestic students, or students who were educated in the standard secondary education system of the UK, and basically that is one part of that is called sixth form. And so what happens is there are these standardized tests, right, that they issue, and depending on the subjects that you study in secondary school, And this is translated into something that's commonly referred to as a tariff. So for example, the highest, possible scores you can get on your three subjects are something like A star, A star, and A star. I mean, that's like, if you do that, that's like the best it could possibly be. And then what universities will do is they'll publish their tariff, right? And the tariff is sort of, so for example, let's say a university says, our tariff is an A and two Bs or something like that. So that gives you an idea, right? So if characteristically the universities that have a higher tariff on average are going to be more, shall we say, selective and therefore systematically more difficult. There's also the fact that if you're a domestic UK student, basically you're applying to 5 universities, usually within the UK, and only one of them could be Oxford or one of them can be Cambridge, I believe. You can't apply to both, but otherwise you get 5. And so there's this entire process. So how does it work? How hard is it? It depends on the university. It depends on things like their tariff. It depends on, a number of different factors. And the process of selection, characteristically, students will indicate an interest. And then universities, and I've been involved in this too, the way University of Surrey does it with their admissions department is we'll have open days and we'll have, and especially if, sort of Surrey, let's say, says, okay, we're going to select you. We think, you meet our tariff and we'd like you to come here. That student might have other offers. Remember, from their 5, right? So then there are days for students who've been selected, and now we're trying to inviting them to come in and answer questions and try to, give them a sense of what makes us distinctive. And we're sort of hoping that, they pick us, right? So that's kind of the way the process works domestically. With international students, the fees are higher, and I think the criteria, and here's where I'm not an absolute expert. Our director of admissions would know more about the details, but there would be a translation, if you like, right, of some of the, the foreign, whatever the foreign credentials are in secondary school to kind of, make an assessment there. And foreign students, if admitted, don't get the benefits of the reduced tuition cost that the UK students who go through that whole other process I described get the benefit of, right? So there's a little bit of complexity there. But I would say overall, that's how I would describe the process. Next, Mean.
Before we move to the next slide, we have a question in the chat. Maybe you can answer it
Oh,
straight away or answer it a bit
yeah,
later.
I'm sorry. What is the, what about US universities? Is that the question?
Yes.
Yes, I'm sorry. Yes, I missed that. I'm sorry. I'm so focused on the slides. I didn't see the slide.
No problem.
Happy to answer that. US universities, okay, so in US universities, which many students from other countries will apply to. I had a student from Surrey who did an undergraduate degree at Surrey and then actually applied for an LLM in a US JD. But you could also have a student who just does a full 3-year JD. So let me say a little bit about that. In the standard 3-year degree in the United States is called a JD, Juris Doctor, and characteristically, people don't do that until after they've already fully graduated from whatever their bachelor's level degree is. So for example, I didn't begin my 3-year JD program at Yale University, right, until long after I had completed my 4-year undergraduate degree in philosophy and mathematics at Drew University, is where I went. And basically, in the United States, I would say the big things that they look at are, we don't have A levels in the US, but we have something else, and that's called the grade point average. Okay, so the grade point average is this number, okay, and basically, if the number is, something like I think the highest number is 4.0. That's like the biggest number on the scale. And then, a high one would be like a 3.5 or something like that, let's say. So that data point is very, very seriously important if you're trying to get into a US law school. The other data point is called your score. It's the score that you perform on a standardized test called the Legal Studies Aptitude Test, or LSAT. It's a standardized test that doesn't necessarily test your knowledge of the law, but it tests your capacities or aptitude for studying the law. So I took this thing, and you have to study for it, but believe it or not, what that test really is all about, to be honest, is logic. It tests your ability to draw inferences, and the questions will not be legal questions at all. But just to see how good you are at reasoning, at analyzing a situation under time pressure, and also at reading comprehension, in the sense that you have to look at a passage and under time pressure extract like the points in the passage that really matter, like sort of to what's going on versus the ones that aren't. And at any rate, that's kind of how that works. And then the other thing I will say is that applying to an American law school, and especially upon admission to an American law school, that can tend to be a very expensive proposition, very expensive. But I definitely don't regret the fact that I did it. But it's when and you're welcome, by the way, if anyone wants to send me an email, I'll just say it once here, and maybe Mila can also forward it. c.taggart at surrey.ac.uk, and I'm always happy to share stories about this to any student, and I have with many of my Surrey students who might actually want to pursue that. So, well, actually, now I'm looking at it, we're kind of getting, maybe this is a good point, if this is okay with Mila, maybe to, because I think we've covered quite a bit. So what I'm going to do is just kind of open things up to a general discussion maybe at this point. And I'll stop kind of moving through means here, and then just invite people to ask questions and allow Mila to maybe, facilitate.
Yes, thank you. Thank you very much. Maybe if we don't have questions, I have one on my own. In fact, I would like to hear your opinion about the last slide, which is...
Sure, let's get to that one.
Okay, this one is important because they're learning on our subject that there is division between big law firms and small law firms.
Yes. Yes. And I also remember one of the memes had to do with prestige. So what I'll do is I'll combine the prestige meme and this meme all in one big meme, maybe. How about that? So, okay, great. So, yeah. So in the UK, this is interesting, right? This is quite different than, for example, in the United States. So in the UK, There are two definitely different kinds of lawyers. And one of them is called a barrister, and the other one is called a solicitor. Now, strictly speaking, it is only the barristers who pass the bar exam. And one of the reasons, they call it the bar exam has to do with the idea that in court, at least traditionally, there's this sort of little wooden bar that you can then pick up, and you're only kind of allowed to pass the bar to like kind of go beyond it, to get up close to where the judge is, to be sort of officially allowed to kind of present a case or defend a case, right? So in the United States, everybody takes the bar exam because all lawyers, among other things, are licensed in the US to kind of represent people in court. But that's not true in the UK. And also there's a kind of a prestige factor, I think, associated with this, because there are only, I believe it's 4 Inns of Court in London that go all the way. Remember, I talked about that common law history, right? And so there's a kind of very competitive sort of process by which one could then try to become a pupil of one of these Inns of Court, right? And if you succeed and eventually become part of that inn, and then you sort of practice law as a barrister in association with that inn, right? It's kind of a pretty prestigious deal. Like, I have a good friend who I think was a barrister at the Middle Temple, right? And these are very posh places. I was actually invited to a dinner at one of these, and I couldn't believe it. I was like, oh my gosh, I wasn't used to it. But you kind of go in there, and like I was not used to this. But like in the front, there's like the head table, the high table, and there are these like clergy and all these people, and and heaven help you if your phone goes on, your smartphone goes off, they will absolutely chastise you. So you kind of have to toe the line. Anyway, but very prestigious, very traditional. And so yeah, that's the path you would go if you wanted to be the kind of lawyer that can officially say, my lord, blah, 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 and wear the wig and that kind of stuff, right? Representing people in court. However, I think the lawyer that I was, for example, certainly much more like I was when I was a lawyer in the United States, is like a solicitor. Now, a solicitor basically does all kinds of stuff other than the going into the court and officially talking in front of the judge stuff. So a lot of the legal research, client interviewing, negotiations, all kinds of things that in the hustle and bustle, like a lot of the stuff that I did, the pre-trial litigation, and advising the barristers, and trying to maybe negotiate a settlement or something like that with the other side, and then they're all that stuff, that kind of stuff that goes on before the trial, right? Because the reality is, in legal practice, a lot of litigation never goes to trial. And in fact, so the idea is, a good solicitor might, be able to help their client the best by actually reaching a settlement or something like that, right? But a lot of taking depositions, a lot of that stuff that happens, but not in the trial, right? That's performed by the solicitors, and then they have their prestige to bring that in. They have their prestige element, which is often referred to as the magic circle. So the magic circle is a set of very prestigious solicitors' chambers or solicitors' firms in London, and characteristically, if you start off as an associate there, and I can, and now here's where I'm going to draw upon my American experience, right? I think it's very similar. When I was a American, sort of solicitor, is kind of what I was. I did manage to get a job at one of these big firms. And this is where you're like billing all of your hours and keeping track of all the time and everything. But it can be very, very lucrative. It was the most money I'd ever made in my life. Um, but right, and this is what I always say. This is my personal advice: is you always have to do what you're passionate about more. I gave, it was really I had tremendous respect for it. And some people are really good at billing those hours, but in the business world, it's really a business, right? And then you start to learn things like again, as a solicitor experience background, I've always learned that the prime directive is do what the partner says the way the partner wants it done. And you have to learn all kinds of this really this stuff, and it's a lot of hours, because what you don't want to underestimate is you have to bill hours, but how much hours actually goes into one billable hour, right? And then there can be pressures, right, to bill a lot of hours, but the rewards are great. So, that's sort of giving you a general sense of the two main lines. But then also, and I'll just share with you something, I think before this meeting, earlier in the chat, you'll find this great big link that I put in there to basically a book on Amazon called "What Can You Do with a Law Degree?" And this would presumably apply not just to the United States but the UK too. And I decided to just give you this link to this book because even though I never read that book, when I decided to study law in the United States, I used a very similar book. I believe its title was something like 101 Things You Can Do with a Law Degree. And it had to do with all kinds of career paths. And this also ties into something I said earlier at Surrey, the idea of that placement training year. A lot of those positions are not at law firms. Some of them are. But a lot of those practical training experiences that are part of Surrey will be involved, like working at a real estate place. You name it. I mean, I even saw one person give a presentation based literally on an entrepreneurial year, right? This person literally tried to develop and market a product that he said, I think it had to do with I think this person was into physical fitness, and it was some kind of vitamins or something along those lines that had to do with promoting physical fitness and health or something along those lines. But really, tremendous variety of possibilities. I mean, if you know how to think like a lawyer and you understand how the law works, that can be a tremendously powerful asset. And indeed, I think a lot of our students at Surrey actually don't become either solicitors or barristers, and I think some of them never intended to. But the rationale is that a law bachelor's degree, an LLB, tends to be a very marketable degree across the board, because if you study law based on everything I've sort of given you a sense of up to this point, right? It's sort of like you can't successfully get a good law degree, like a first or an upper second or something like that. It's not possible to do that unless you have actually internalized these powers or know-how, this ability to solve problems, in addition to understanding how to access and research very, very important information, right? So, I mean, if you can do that, for many students, I guess the sky's the limit, and they take it in many different directions. So, how prestigious is it? It depends on the direction, right? So I would say, I chose to take my legal education in I don't know if I would call it a prestigious direction. I feel kind of proud, but for me, I love to, I always, my personal recommendation is to follow your heart and, whatever you do with it, right? Be passionate about what you do and have integrity in what you do. And I've always found that to be the best advice for me. And so that's what I suggest to my students. But of course, the choice is yours. Is
I
that
completely agree.
is that the kind of thing you think, Mila? Is that yeah? So that's what
I,
I would say, kind of on that mean.
I have chosen the sociology of law, so that means that I have chosen the path of heart and not the
You
money.
have chosen the path to prestige, riches, and glory. No, no, you have to choose seriously because this is what you're doing right with your life, right? So you want to think about that. Yeah.
We have
So
one, excuse me. We have a question in the chat by student
yeah.
Ogin Maric. Do you think that Anglo-Saxon legal system, as far as the trial is concerned, is based more on the emotional moment than on the law itself?
Boy, is that a great question. So, arguably, I think that, okay, so just to back up and say a little bit here quickly, um, in England and in the United States and similar countries, the trial system is based on what's called the adversarial model, as opposed to what is common in many countries, which you could call the investigatory or maybe inquisitional model. Inquisitional sort of sounds like this old-fashioned, thing, but the difference is this, and it matters. That's a great question. So, in the adversarial model that we have in the UK and in the United States, the the claims that are brought and framed are in the control, the primary control, very heavy primary control of the adversary, the private parties. And yes, the judge is there kind of as a referee, but the development of the evidence of the case is not carried out by the government. Um, Instead, the judge is sort of there as a kind of a referee, and then there are all these rules that will say, okay, if you're this side, you can force the other side to answer interrogatories and all this other stuff. And a lot of this is going back and forth because the trial itself, okay, especially, for example, like a criminal trial in the UK or in the US, my goodness, in the US, even with a civil trial, okay, are decided by jurors, right? Now, if you think about this, these are people who are not trained in the law, okay? These are people who are selected for jury duty, and in the UK, very commonly for the criminal, and in the US, it's like all over the place. I mean, so for example, civil and criminal. And so what can happen is, if you're the lawyers and you're going back and forth with your adversary, a lot of it is about sort of trying to convince your adversary that if you go to trial with me, I'm gonna really be able to win over the jury or win over the judge. And I can, from this back and forth where we're forcing each other sort of to disgorge evidence, right? You say, look, if you don't settle this case and we go, right, I'm going to win, right? And if you can now, and part of that argument very much is that in reality, a lot of people know that in an adversarial system, you've got this passive decision maker, and it's sort of showtime, right? Where, this side gets to bring its side. It's usually either the plaintiff or the prosecution goes first, right? And then that's it, right? And then the defense gets to go. And then what happens is the judge will then basically try to educate the jury as best as the judge can in this relatively brief statement just about what the applicable law even is. And then depending on the type of verdict, right, in a criminal case, it's easy. It's just guilty or not guilty for every count. But in a civil trial, my goodness gracious, I mean, there can be all these forms. And so the jury then goes back into the room and then just, is unaccountable, right? The jury doesn't have to write a legal opinion to justify whatever their verdict is. And I think that only a fool would believe that emotions don't play a role. And people who are excellent at what they do in trial, whether it's an excellent barrister, trial lawyer in the UK, or just a good trial lawyer in the US, and some of them specialize in this. And in fact, it gets to the point where there are even specialists who advise lawyers when a jury is selected. Say, strike that person. Do not let that person get on the jury because they're going to vote against it. It's quite sophisticated. So yes, excellent question. I would say the answer is yes. It has a major impact.
Perfect. Thank you very much. We have two more questions in the chat by
Okay.
students Branko Simic, Elena Stojic. I can read both of them and then you can answer.
Yeah, sure.
So how should legal education adapt to address emerging areas of law, such as cybersecurity, artificial intelligence, and environmental law, ensuring that students are equipped to tackle contemporary legal challenges? Really contemporary topic. Now everyone are crazy about AI. And second question, do solicitors especially need to have a JD or they are only required to pass the bar exam? Could you take the bar with an undergraduate degree in a different subject? Yes, so.
Yeah, okay, excellent. Yeah, so, okay, in the United States, all right, let me take the second one first because I can just kind of give a direct answer to that. So we're talking about the JD, we're talking about passing the bar in a United States jurisdiction, right? So I would say there are two different ways, major different ways that a student, say, who's not from the United States would do this. And of the two, the much less financially punishing, that requires as much money would be the LLM. So the way that works, and I was very much involved actually when I was at Harvard Law School, I would teach classes specifically geared to students who came from other countries to Harvard to take the LLM precisely because they wanted to pass the bar exam, right? So I know a little bit about this. So some states, and notably New York and California, which are two of the biggest, kind of most sort of legally important states, in terms of getting licensed that there are. They also tend to be pretty tough. But what they do is they say, look, if somebody's not from the United States, but their undergraduate degree, whatever it is a law degree, right? So let's say, you're from a country that does undergraduate law. Then you could apply for the LLM. Now, the advantage of that is it's only 1 year. there are going to be certain requirements, like, so for example, they're going to make sure that during that 1 year, you study American style legal research, writing, and analysis. And I used to teach that there, because the thing about the United States is it's jurisdictionally wildly complicated, right? Like really complicated. So, basically the legal citation manual is called the Blue Book, and it's just, and just getting used to it. You also have to know a lot about enough basic American doctrinal law to pass the main elements in the bar exam, which will include the multi-state bar exam, also in New York and California, will include contracts, tort law, evidence, constitutional law, try to remember all of them, criminal law, and property. I think those are the six. And, you're going to have to take those. But that's one route. And so the answer there is, yeah, you wouldn't need to even have a JD, right, to convince those states to allow you to take the bar exam. Now, the other possibility is, let's say, I'm from, not the United States, and I studied, I don't know, English literature or something like that. Could I take a JD? Yes, you could. In fact, if you look at the types of subjects that people study as undergraduates, as Americans, for example, we don't have law, right? You don't study. So there's statistics that show you, depending on what you studied as your undergraduate, how well you tend to do on things like the LSAT that I described earlier. And some of the highest scorers are people who studied like physics or mathematics or something like that, right? So this is possible, but if you don't have either a JD or an LLM from some accredited American law school and the Association of American Law Schools, then I can't think of any state in the country that's going to allow you to take or sit for its bar exam. That's the idea. So it's going to depend, but those are the two major things. Now, the other question was a profound question and a very important question. How do we deal with, how should legal education be systematically adjusted, if you like, to accommodate these new needs that we all have in a changing world. Now, my personal views on this is that I think for now, the approach, at least that UK universities are taking and should take, it goes back to some of the things that I mentioned earlier, right? You're not going to be able to cover everything, right, that covers every dimension, maybe, in 3 years. But for example, I would say for students who want to do the law and technology program that I mentioned earlier, there are a number of different modules that are designed specifically. I'll give you an example. We have a module on cybercrime, right? I mean, that module wouldn't have existed. Also, we have a pan-university artificial intelligence initiative that the law school feeds into. And in fact, we have a member of the law school staff whose primary appointment is connected to artificial intelligence. So I believe that, the general approach that universities need to take in the UK or elsewhere, just generally, it would sort of stand to reason, would be to sort of recognize the absolute need for this. And this also translates into employability, right? So I guess the answer is, I think, trying to do exactly the kinds of things I described in general that the University of Surrey in the UK, and I have no doubt many other universities around the world, are sort of being forced to reckon with, right? If the university doesn't then its students just won't be adequately educated. Um, you know, so that's an excellent question. Yeah.
Thank you very much for answering, first commenting the memes and then answering the question. I found the meme specially designed for this kind of question. We have one more question from Professor Lilic.
Okay. Let me first of all, Chris, thank you for your presentation. I think the participants, and they grew to a enormous enormous group of people, something like over 400.
Wow.
It really is a lot. So I think the two things I wanted to say. Actually, I have 17 things, but I'll just say two. One is, could you maybe say something about the paralegals? We don't have paralegals in our system. Okay, so you the thing you put on the slide is that they're very important. However, they're the chair bearers, right? So they bear the burden of this. And there was another slide which I enjoyed very much. It was a slide that says, any tips on what is the essential skill of a good lawyer? Am I right? There we go.
Yeah.
What are essential skills for a good lawyer? Any tips? Okay, I'm going to give you a tip, which is absolutely applicable, but I think you'll have to, or anybody that applies this tip has to buy me a beer if we're in the UK. If we're in Europe, we can do with an Aperol Spritz or something like that. And the tip is, a good lawyer never asks a question to which he does not know the answer beforehand. Okay, so never ask a question which you don't know the answer to, because that's a lot of trouble you can get into. And I think this works, which also means this is not only humorous and lighthearted, but also it means that you have studied your case. Okay, so you know all the facts of the case, and this is how you win the case. You have to know all the facts. You have to know the facts better than the other side. Okay, so you have to work double. And there's a good movie I recommend for, let's say, reasons of instruction, how to win or how to achieve success. Maybe win is like a military word. However, the movie is military, and it's called Patton. This is George Patton, the American general, and we have George C. Scott playing George Patton. Okay, and this is the Battle of El Alamein, the famous battle in northern Africa, where on the other side you had the invincible, the unbeatable Rommel, okay, Irvin Rommel. And there's a scene in the movie which is excellent. You have this guy, Patton, that is to say George Scott, standing on a mound, on a hill, a typical American general, with the iron shirt and the iron and the tie, with the helmet, and his hands on his back or something. And he says something like SOBs. SOB is a swear word, okay? SOB. I read all your books. And so he read all his books, and this is how defeated the undefeatable Roman. So this is what you do in court cases. You read all the books, okay? So when you ask the question, you manage to get the process going your way, okay? Now the paralegals.
Well, thank you. Yeah, that's great. Yeah. They say, if the law is on your side, you argue the law. If it's not, you argue the facts. But the point is, you got to be prepared. So thank you. Yes, excellent. On the paralegals, I'll say a little bit specifically about them. So I remember working with a lot of them while I was at the law firm. So I was an associate, and as a junior associate, suffice it to say that, well, you might not get the most glamorous of assignments, but the people who make it really happen are the paralegals. So I'll give you an example of the kinds of things that paralegals have to be capable of doing. And I'll do this by sharing with you a little bit about a case I was working on a lot where I had to work with paralegals, and they were excellent. So one of the cases that I had is as a junior associate is that we had a client who created this medication, and suffice it to say that lots of people were claiming that there was something about this medication that was substandard, and that it was because of this medication, that they had this problem with their health, and and then they were suing, and there were these plaintiffs from all different states, and I was assigned on, in effect, the defense team for claims coming in through, I think it was New York, mostly in New Jersey. At any rate, I mentioned earlier that a ton of the actual litigation that occurs never happens in a trial. A ton of it, right? And remember, I mentioned there were all those rules I talked about, like being able to ask people questions and submitting interrogatories. Well, I would, we had all kinds of these letters, and for each and every single given case, there were certain letters and a certain file, and there were all these standard things, and there were these, in our case, there was a certain set of medical tests, and each person who was bringing the claim had to have evidence of these medical tests. And so my job as the associate, one of my jobs, and this also goes to the professor's point about knowing the answers to all the questions, especially before you ever go to trial, is my job was to depose a lot of the people who were suing, right? And if you depose somebody, then basically you're getting them officially with a stenographer to basically answer all these questions, right? So that in case it ever does go to trial, right, and these people become witnesses, and you ask a question and the answer, that they gave in the deposition, that's how you know. And if they don't answer that question the way they're supposed to, then suddenly they go, boom, in trial, they say, can you show me the deposition transcript here? And then you can try to impeach the witness. It can be pretty bad. I remember one time along these lines, and I'll just quickly share. Among the people that were bringing lawsuits were people who didn't take the medication, but who were the partners of the people who took the medication. And they were claiming that, oh, well, because my partner took this medication, it's ruined our relationship, and all this. And so I'm suing, not because I took the medication, but because I think your medication caused my relationship to be really bad, or something like this. Right. And I remember one time deposing one of these people, and I was just, asking questions, and I was okay at it, but I'm no great, master, tactician or anything, but I was just asking questions. But I did notice there was something peculiar in the file. Now, the files that I used to prepare, that's where the paralegals come in. They have to keep track of all that stuff and manage all of that, and keep all of that going in and knowing how to organize it. And even though they're not lawyers, they have to have enough legal knowledge to understand the significance of all of these files and how they relate to the case that they're ultimately supporting. Right, so that then when, say, even the junior associate, like I say, look, I've got this deposition coming up, I have to depose Mr. Jones or whatever it is, right? I then would work with the paralegals, and they would really help me out and make sure I had everything in order that I needed to even research to do the deposition. So all of this was provided for and organized by the paralegals. So I got the file and I went through it, And so then I noticed some kind of peculiar financial things in the file, suffice it to say. I won't go into all the details, but I was just puzzled by this. Now, I wasn't, this was just a fact deposition. I was just there exploring facts. I wasn't expecting anything to happen, but I did notice some peculiar things here. But this is because of the paralegals who gave me all this. So I looked at this and I said, okay, well, I'm marking this as this exhibit and then marking this as this exhibit. I said, Mr. So-and-so, I noticed here in this exhibit, it says blah, blah, blah with this money or whatever it is. And on this exhibit, it says, this other thing. And I just says, I'm just curious why, this, it's just, can you explain to me why it's like this? Because I'm just trying to understand. And then all of a sudden, there was this moment of silence. And he said, well, okay, I may as well say it now because it's going to come out. I was cheating on my partner this whole time, and and what this was the money that I was putting into this fund where we could go away and have our affair at whatever the hotel. What I couldn't believe it. I was like, holy cow! Well, at that moment in my mind, of course, I'm thinking to myself, and you're suing my client for millions of dollars because you're claiming that it was my client's, medication that ruined your, maybe it was something, I didn't say that, but I knew, right, that once we had that, right, there was no way. I mean, and this goes back to the other thing somebody said about, the emotional influence, right? I mean, if they ever brought that to trial, I mean, this guy would be totally destroyed right on the stand because he'll just, is it true that you were cheating on, and you'd have to admit it in front of a jury, let's say, right? So all of this, at bottom, the point of all of this is that none of this would be possible without the paralegals, right? They are the ones who manage the files, and they are the ones I, as the associate, for example, this was not one of my glamorous assignments, and this is before the computers. Now, it might not be so bad. If you know how to use a computer, and that goes to the law and tech stuff, you need to know how to do this. But we didn't have the computer, right? So I had to go through literally, I would go into this room, and there would all be these bankers boxes full of documents. And I would just have to spend hours going through the documents for various reasons. So if they were our documents, my job would be to identify documents that we legitimately could claim attorney-client privilege for. And if we couldn't, then we would have to give those documents to the other side, and we of course would, but absolutely legitimately we're not. But it would be but what about the bankers' boxes themselves, and where do those documents come from, and what keeps them organized? Paralegals, right? So the paralegals are really that underlying practical, necessary, and I would imagine even today, and although it's been a while now, I was in legal practice in the early 2000s, so things have changed. But 25 years later, almost now, 20 years later, I would imagine that the paralegals themselves are going to have to be facile with the computer technology to kind of continue to do the analogous kinds of things that they're doing to support the junior associates, who then also have to know how to use computer technology to search for possible attorney-client privilege stuff, right? So it all feeds up that chain. That's a great question. And a lot of UK students will get some of their first work experience as paralegals. And it's also a great way, if you're interested maybe in becoming an associate at a firm and really seeing what it's like, right? often, becoming a paralegal is a very wise investment before you sort of fully take the plunge, as they say, right? In investing in, if you're in the United States, like a JD or something like that, right? A lot. And what would happen is I would wind up writing letters of recommendation for some of the paralegals that I worked with when they decided, yeah, I want to do this. And I remember writing a couple, some great paralegals, and they got into some great law schools like Berkeley, Bow Hall. Remember that very distinctly. So yeah, that's a bit about the paralegals.
Thank you very much. We have two more questions regarding more or less the same topic. You can
Okay.
answer it really briefly because we are now entering in more
Oh,
than
no,
90
that's
minutes.
okay. I don't want to hold people, but I'm willing to just keep going. I'm in no rush. So if people want, I'm willing to keep going. But so, what are the questions?
So throughout the history, the UK has had many countries under its crown. Many have remained so to this day. Does the legal system in the colonies match the system in the UK, or are there still certain specificities? Thank you in advance. And kind of follow-up question. Better question is how much did UK influence law and legal system in its ex-colonies? I don't know if you're the right person for answering that question, but probably.
I can only say something on that point. Especially, I mean, it's sort of, in a way, I know this is going to be kind of maybe the obvious thing to say, but for me, but one thing I can say is that, of course, the United States started off as, a bunch of English colonies. And I can assure you that at least when it came to how the American colonies that eventually became states, each state to this day has its own common law, for example, of contract. And it definitely was substantively, the substantive law itself, way back in the late 18th century now, in the case of the United States. I mean, in effect, when they became sort of the states and then the states created their own judicial system, originally, and it's kind of ironic, but in the United States, actually, the real prestigious judges, the real were the state judges. And this was sort of ironed out, this evolved, but early on, um, it was like the state judges, which is where it's at. And when they started, the states had a lot of common law, even more than they have now. And effectively, it wouldn't be uncommon for a state to say, well, as of whatever the date is, the common law of contract in New Jersey or whatever it is, pretty much just is the common law of contract in the UK as it applied to the colony that New Jersey was, basically. But then things took off, right? Because then once New Jersey now has its own independent, authoritative judicial system, right? And indeed its Supreme Court, that judicial system over the years carries on that common law tradition, right? The judges don't just interpret the law and thereby interstitially make new law, like in those cases like the baby carriage, right? I mean, that's true even when judges interpret a statute, right? But we're talking about full blown, like literally making the law, right? It's like the Supreme Court of the state of New Jersey is the highest authority there is, right, when it comes to what the common law of contracts in New Jersey is. Now, of course, the New Jersey legislature right, could say, well, that's all fine and well and good. But guess what? Statutes trump common law, which is true. Remember that whole thing about Parliament coming in, right? So that whole dynamic is there. Now, uh, as far as the extent to which actual legal practice, like how is a trial run and so forth, I think the only answer I can give to that is it's going to vary a lot. And I'm not an expert, right? That's the only answer I can give. Certainly in the United States, there's now been a lot of divergence, right? I mean, we don't even have two different kinds of lawyers anymore, right? And you know, even the norms, the stand, like in England, and I think in many of the former colonies that were part of the Commonwealth, right? Even if insofar as they become independent, I mean, a lot of their judges will, you know, they'll characteristically sort of look like judges in England, right? They'll have these big wigs and things, and only certain people can wear the wigs and so forth, right? And that stuff doesn't go on in the United States. So that's the best answer I can give there. I wish I could give you more specifics, but it just goes beyond, I'll be honest, it goes beyond my expertise to say more.
May I add something
Yes.
before you
Of
go to the
course.
second question? The influence that actually the common law system had, as Chris pointed out, is paramount in the U.S. What's interesting in the U.S. is that the U.S. practically took over the revolutionary French political system in the division of powers, but the judicial system remained English, okay, or common law. One thing. Another thing, and of course, it's a republic, and this is a monarchy. Now, the question was, what about the other colonies? My not too argumented answer to this is, for example, India, or for example, Nigeria, even Pakistan. All right, those are countries that, with all their ups and downs, basically are not dictatorships. Okay, so imagine a country as big as or diverse as India, as the United States, to a certain extent, also Nigeria. I don't know if you can put South Africa into this. Maybe you can, but still, and also Pakistan. For example, lawyers in Pakistan are a very special class. They're very, by the way, they're excellent. By chance, I knew some of them, both men and women, were excellent lawyers, you know, old traditional, excellent lawyers. I would, if I were a person convicted, I'd take one of them as my lawyer. So this for me is, so this maybe is a tentative answer. What is the effect? I would say the effect is positive, not negative. Okay. Well, that's it on this issue.
Yes, perfect. Thank you. Thank you very much to Professor Lilic. Thank you very much to Christopher, or Chris, as he introduced himself. I hope you all enjoyed. Chris, I hope that maybe this can be a beginning of, not to quote Casablanca, great friendship, that as well, but a great tradition to have these kind of workshops in the future years as well. So at this point, I will just thank you and then move to speaking a bit in Serbian, just to my students to have some more ideas about notifications, that I notify them, that they will get their points for being here, etc., etc., and also to use time to tell them that tomorrow they have one more seminar about the future careers, but in Serbia. So now they had some wider angle about possibilities in UK and US, thanks to you. And tomorrow they will have some experiences from Serbia. So Chris, thank you very much. Maybe you can just stay here a bit to like kind of, I don't know, have a discussion how it went, and then so I will now speak in Serbian, then go back to English. Perfect.
Okay. Thank you, Mila. Nice to have met you, Chris. Hope to see you again sometime.
You too, Professor.
I'm going
Thank you.
offline.
Thank you.
Okay.
Thank you for being
Si
here.
vous permettez, si vous permettez, I'm going offline.
Thank you very much for joining us.
Bye-bye.
So now in Serbian a bit. Dobro, hvala vam puno što ste bili ovde. Dakle, sutra imamo predavanje u 5:30 u Petici. Dakle, ko se nije upisao da je prisutan, neka se upiše. Ja ću to upisati u Excel tabelu. Vidimo se sutra i na vežbama ujutru. Vi ko radite po Vuković knjizi, vidimo se u četvrtak ako radite po Bovan knjizi i vidimo se u petak na kolokvijumu. Tako da, hvala vam puno što ste bili. Možete da, ako ste se upisali, možete sada da se isključite. I to je to, vidimo se sutra. Prijatan dan svima. To je ostatak večeri. Okay, so Chris, did you enjoy? I will now stop recording, so officially it's over.